Great to have you with us on SABC's Prime News. The Supreme Court of Appeal has heard that the President's powers to reshuffle cabinet is an executive decision which should be protected from disclosure.
The former President Jacob Zuma is challenging the ruling by the High Court in Pretoria to disclose reasons for the March 2017 cabinet reshuffle. At that time, Zuma argued that he'd received an intelligence report that former Finance Minister Pravin Gordhan and his deputy Mcebisi Jonas at the time wanted to depose him.
The DA challenged former President Jacob Zuma's decision to effect cabinet changes. The party argued that Zuma had acted irrationally when he fired Pravin Gordhan and Mcebisi Jonas. The High Court ordered Zuma to divulge records for his decision, but the President disagrees, arguing the High Court judgment should be overturned and that the DA's application violated the doctrine of separation of powers.
Cabinet reshuffle is an entirely different executive function. There is no record of anything. There's no duty to consult with anybody about it. It's a political decision, it's a polycentric decision made by the President himself and cannot in itself implicate the production of a record.
The DA argues the President has no unfettered powers and that his decisions are subject to the constitutional scrutiny.
The only way to properly test public power under review is to provide the record. That's what the Constitutional Court said last week. That is binding on this court, but in any event it endorses all of the things this court has said for the last 5 years.
Some analysts contend that political decisions are bound by the Constitution.
It is often the President who can appoint and actually dismiss members of Parliament, but at the end of the day, he himself has also been appointed by his own political party, so he needs to take them into confidence when he takes such major decisions.
Judgment has been reserved. Aphumelele Mdlalane, SABC News, Bloemfontein.